Again, good morning, and thank you for joining us today as we discuss workforce solutions for employers and their employees. You know, during this COVID pandemic, employers have been faced with many challenges. And while they may have been prepared for temporary interruptions, these long-term interruptions have them looking for solutions and opportunities that will help them sustain their business through 2021. So just to let you know, this webinar is being recorded and will be made available and posted on our website at www.forwardboone.org. I'm Pamela Lopez-Fedez. I'm the Director for Economic Development in Belvedere and Boone County with Growth Dimensions. And thank you very much for joining us again. Today's session, Heather, if you can advance the slides. Today's session has been brought to you by Growth Dimensions and organizations you see before you that make up Belvedere and Boone County. If you can advance to the next slide. Thank you. We came together in the spring to combat these issues and potential solutions we were facing as a result of this pandemic. And I have to say that as part of these leaders coming together, we've been able to provide relevant, timely, and locally focused information and resources for you. This is one webinar in several resources that we have on Forward Boone. So please let us know how we're doing and what we can do to provide you with those resources. Next slide, please. I'd like to take the opportunity to introduce Sam Castree. Sam has been the Senior Vice President and General Counsel for Staff Management Incorporated on Morrissey Family Business. His responsibilities include Chief Legal Officer and Management of the firm's human resource outsourcing services. He has evaluated and established procedures and policies for labor and employment law, risk management, and compliance. This includes EEO, FLSA, Fmla, and ERISA, reporting and disclosure. He has developed and implemented numerous HR consulting projects, including human resource employment law audits, harassment training, and management training programs. He is also responsible for non-competition and other employment related contracts, as well as general corporate related issues. He's a valued counselor for difficult HR issues, and his labor and employment law background combined with his practical HR experience provides exceptional solutions for firms and businesses and HR partners across the board. While in the private practice of law, he's counseled many employers on a full range of labor and employment law issues and policies. Sam has presented employers in the state and federal courts, a labor management arbitration, and before administrative agencies. He is also a frequent speaker and a trainer on labor employment law topics, having spoken before regional, statewide, and local organizations, as well as numerous in-house company-sponsored seminars and training sessions. So before I turn this over to Sam, I want to remind everyone that this is being recorded, and after Sam is finished, we'll have the opportunity to ask some questions. And please feel free to put your questions in the Q&A feature in the bottom of your screen, and we'll address those at the end of this presentation. Sam, thank you so much for taking the time with us today and joining us and providing your expertise. The floor is yours.
Great. Pam, thank you very much, and you're welcome. I appreciate the opportunity to be here. My goodness, I should have given you the short bio, not the long one. I don't have time to talk anymore. We're wasting the good training time. But thank you for the introduction. And thank you also to Pam and her staff in helping develop the agenda and what issues, are important to the employers attending the presentation today. Certainly, it seems nonstop with the changes in the law or updates or just whatever might be going on in the workplace driven by the COVID pandemic. Here today to hopefully offer a few solutions and frankly, probably just remain with a few questions, unfortunately, as we approach year end and trying to look into the future and see what that might bring. But as Pam mentioned, I encourage your questions. If you've got any, please feel free to, again, put them in the Q&A box and we'll get there. So my presentation, probably another 45 minutes, give or take, time for questions, and we'll have you out of here in about an hour. Let's see. There we go. What exactly are we going to talk about today? Start with, I think, a brief discussion because it will be relevant. Differences between the traditional Family Medical Leave Act and provisions of the Family First Coronavirus Response Act. And even though that law has a sunset provision of 12/31, so just a couple weeks or so, we certainly might anticipate that that would be extended, although there's nothing given right now, but also there are a handful of year-end issues revolving around that. And then I think from a practical standpoint, your employees likely still will need some time off, whether it's because they contract the illness, whether they're exposed to the illness, whether they have family members that are ill, children in school. Those things aren't going to go away at year end. We have to determine maybe what are some options legally or just HR best practices or suggestions on how to handle that. So also some return to work issues. I continue to get a number of questions, although many of us have had employees unfortunately become ill or exposed to the COVID virus in the workplace. The CDC has continued to change several times some of its guidance, so we'll look at that. And then maybe briefly, what might the future bring under a Biden administration that will address some of these issues? So with that, let's kind of dive in. The big question has to be, will the Families First Coronavirus Response Act and the Emergency Family Medical Leave Act provisions and the Emergency Paid Sick Leave provisions, will those be extended into 2021? I've done a lot of research and I saw an article from an attorney, big, I think, Washington, D.C. law firm. And I like to quote what he had to say about that. His quote was, "I have no idea." So if he doesn't know, I guess I don't know either. I suspect something will happen. This morning, I did double check the current bills. There are two bills before the Congress, and I only know what I read, no special insight, but you could Google as well. And they said one bill has a really good chance of passing. There's a second companion bill that maybe not. I've done a quick review of both of those and put in some search terms, and frankly, haven't seen anything extending the leave provisions of the FFCRA. Some of the other provisions of the FFCRA, for example, extended unemployment, that looks like that will be extended if these bills are passed and signed by the president through April. So we have to wait and see. But at least as I was able to look at it this morning, nothing in the current bills, and of course that could change, that extends the emergency paid sick leave, emergency Fmla provisions of the statute. So what do we have? Excuse me. What are some of those basic differences and issues? Again, briefly, recall that under the FFCRA, this is only for your, I will say, smaller employers in the macro sense. So fewer than 500 employees, which obviously is a lot of employers in our region. On the other hand, the FMLA only covers employees with 50 or more employees. So that is going to exclude some employees that are otherwise covered by the emergency family leave and emergency paid sick leave provisions. Recall that 50 employees is not FTEs, it's just 50 bodies. They could be all part-time for that matter. They may not be eligible, but you may be a covered employer if you have 50 or more employees for 20 or more work weeks in the current or preceding calendar year. So 2021, we look back into 2020 as we approach year end. Who are eligible employees under the EFMLA, Emergency Family Medical Leave provisions? Well, that's just, employee just has to be employed for at least 30 calendar days. So if someone was hired after December 1, they're obviously not going to have anything at this point. They'll become eligible about the same time it expires, but others will. On the other hand, the FMLA, there are the traditional requirements that they've been employed by you as an employer for at least 12 months, that they have at least 1,250 hours of work, so about half time, a little bit more than that, in the last 12 months, and importantly, that they live within 75 miles of at least 50 other employees. So there are some differences there. Then we compare the emergency family medical leave provisions to the emergency paid sick leave provisions under the FFCRA. Emergency paid sick leave, all employees are eligible regardless of tenure. If they get hired tomorrow, they get COVID tomorrow, they get the benefit under the statute, unlike the EFMLA. Again, the FMLA provisions go unchanged in that regard. The length of EFMLA is 12 weeks through the end of the year currently. The traditional FMLA, you're covered by that. Again, it's 12 weeks in a 12-month period. Importantly, you should, of course, have an FMLA policy. As important, you should define, if you haven't, what that 12-month period is in your policy, because it does have consequences. Will you use merely a calendar year? Will you use some sort of fiscal year? Will you use what I recommend, kind of a rolling 12-month period or a 12-month backward looking? So when someone requests FMLA leave, look back 12 months and see how much leave they've taken. And then if they've taken none, they've got the full 12 weeks. If they've taken some, whatever the balance is of that 12 weeks. Why is it important to define that? If you don't, the Department of Labor, the courts will assume a 12-month period that is most beneficial to the employee, which is typically going to be, and certainly in this case right now, a calendar year. So instead of getting maybe 12 months in a 12-month period, someone could get 12 weeks in a 12-month period. They get 24 weeks in a 24-week period. Let's say someone had a serious health condition at the end of the year. So October, November, December, roughly 3 months, they're on leave. January 1, boom, they refill that FMLA bucket if you don't define it in your policy. And all of a sudden, they've got January, February, and March off as well. So that's fine if you'd like to do that. Nothing wrong with it. Better perhaps to make sure you define what that 12-month period is in your policy so that you understand what you're agreeing to regarding leave. What are qualifying events? Excuse me, a touchy mouse. EFMLA. There is one and only one qualifying event. Sometimes I get questions about this, and there seems to be a little confusion. The only qualifying event is that a child's school is closed, or the child's daycare, I guess maybe that's two. The child's daycare is closed or becomes unavailable. That's it. It has nothing to do with whether or not an employee has COVID. It has nothing to do with whether or not an employee's child or other family member has COVID. No, it's only if school is closed or daycare is closed or unavailable due to COVID. Only qualifying event. For FMLA, of course, the typical qualifying events are the serious health condition of the employee, the serious health condition of an employee's spouse, child, or parent, or the birth, adoption, foster care placement of a child. There are some others that probably really aren't relevant to this presentation regarding some military leave, et cetera. But as again, regards this presentation, those are the ones that probably are the most relevant. The emergency paid sick leave, here's where we get into issues of individuals being sick or family members being sick or showing symptoms of COVID. And so there are actually 6 qualifying events here. One is the employee subject to quarantine or isolation order. We're aware of that. When we had our shelter-in-place order, that was considered to be a quarantine or isolation order by the state government. And so when an organization had to close because of that would qualify for the 2 weeks of emergency paid sick leave. A second one, the employee is advised to quarantine by a healthcare provider, or the employee, importantly, employees experiencing symptoms and seeking a medical diagnosis. That question seems to come up a lot. Someone's got the sore throat, they've got the dry cough. they've got the headache, whatever those, maybe they're running a low-grade fever, whatever those typical symptoms are of a potential COVID infection. They have those. They go to get a COVID test. They go see their physician, whatever it might be. Even if it turns out they did not have COVID, this would qualify because they have experiencing symptoms seeking a medical diagnosis. Again, FMLA qualifying events don't change. Those are the first three. There are three others, and the employee is caring for an individual who's subject to a quarantine or has been advised by a health care provider to quarantine, or then the same reason as that emergency family medical leave. Employee is caring for a child whose school or daycare provider is closed or unavailable, again, due to COVID reasons. There is a sixth reason I haven't added there. It's kind of a catch-all. Any other reason that might be provided by the Department of Health and Human Services, they have not provided any other qualifying events. So that's just not operative. I don't mention that. What's paid, what's unpaid? Well, under the Efmla provisions, again, there are up to 12 weeks of leave. The first 2 weeks of Efmla are unpaid. But as we mentioned before, another qualifying event under the emergency paid sick leave is child's school is closed or daycare is closed or unavailable due to COVID reasons. Those first 2 weeks could run concurrently, 2 weeks of paid EPSL, as well as 2 weeks of unpaid Efmla run together. The remaining 10 weeks then would be paid. All of those for that particular reason are capped at two-thirds of an employee's regular pay, capped at $200 per day or $10,000 total over the course of the 10 weeks of Efmla. FMLA, traditionally, that is unpaid as required. However, employees may use available sick leave or other available PTO that fits, or you as an employer may require them to take available paid time off, whether you call it sick leave, vacation, or just a catch-all bucket of paid time off. You can require employees to use that when they are in regular FMLA. Oh, I think I skipped one too fast. Here we go. The EPSL, emergency paid sick leave, the pay there, it is paid for the first three reasons. Again, quarantine, you've been advised to quarantine, or you have symptoms and you're seeking medical diagnosis. That is at full pay, but it is capped at $511 per day or $5,110 total for the 2 week period. For the other reasons, you're caring for someone who has COVID, you're caring for someone in order to be quarantined, or your child is off due to closure of school or daycare for COVID reasons. That again is that same 2/3 pay capped at $200 per day. And again, regular FMLA is unpaid. That's a quick review summary of the FMLA and FFCRA changes, or I should say comparisons. Let's get into the hard things. What are some options that employees might have? What are some employer obligations you may have if an employee needs to stay home with a family member? And that really falls into two categories, just as the FFCRA leave really falls into two categories. One, a family member might have an illness, or two, the family member would have a child who has to stay home because school is closed or daycare is closed. So what if an employee has exhausted emergency paid sick leave? And probably many employees have, or now we're looking at January 1, 2021, and there is no emergency paid sick leave. What are options? Well, if the employee is sick, of course, and you have 50 or more employees, you're a covered employer. Then the employee would have option of using regular FMLA. If you are an employer that has fewer than 50 employees, obviously this doesn't apply to you, because it would be typical that someone who's ill with COVID would have a, quote, serious health condition. So if the family member is sick, serious health condition of a spouse, child, or parent is a qualifying event. Now, sometimes we think of serious health conditions as being really major things. And if you were to look back years and years ago, right before the FMLA was enacted, the congressional record, the floor debates talk about very serious things. They talk about cancer, they talk about heart disease, and things of that nature, some very serious conditions. Well, after the law was enacted, and much to the frustration, I'm sure, of many of you and other employers, that definition had some things that maybe weren't quite so serious. And an early opinion letter talked about the flu. So not unlike what we're experiencing now, I think that could the flu be a serious health condition? Come on, most flus aren't that bad. And the opinion letter said, well, yes, if it meets the qualifications of a serious health condition, yes, even the flu could be a serious health condition and require protected FMLA leave. And so what are those serious health conditions? Why is that perhaps a sometimes fairly easy burden to meet? Well, one of the definitions in the regulations of a serious health condition is anything requiring a, quote, continuing medical treatment. And one option of the kind of the subset of continued medical treatment is an incapacity of greater than 3 days. So when the original opinion letter came out, yeah, someone had a bad case of the flu and they were sick for 4 days. They were incapacitated for 4 or more days. That's a serious health condition. And certainly with COVID, people may very well be incapacitated for more than 4 days. That incapacity requires either 2 treatments or continuing treatment by a doctor. So many times we aren't necessarily at this point, we're not seeing physicians. They're saying, look, just stay home. Here's your course of care. Get plenty of rest, drink plenty of fluids, be socially distanced, use good hygiene practices, et cetera. That could very well then qualify as a serious health condition. The questions there become, so COVID being a serious health condition almost in all cases, does the employee have any 12 weeks remaining? Have they already burned through their FMLA when they use their EFMLA for their children? So if you have employees that have small children and they have used 12 weeks of EFMLA already this year, guess what? They don't have any FMLA left because that EFMLA counts as regular FMLA. And you don't get 12 weeks of EFMLA plus 12 weeks of regular. It's 12 weeks total. And that's why your definition of 12 weeks in a 12-month period becomes very important. Because if it is just a calendar year, or you don't otherwise define it in your policy, then as of 1/1, that employee will then likely get a new 12 weeks dropped into their FMLA bucket, if you will. So even if they may have used up all their FMLA as EFMLA through the end of 2020, if you don't otherwise define it, again, the courts or Department of Labor will define it for you in a way that is most advantageous to the employee, which in this case would be a calendar year. And so they're going to get a full 12 weeks. So I advise you to double check what your policy says. I don't think I'd necessarily change it right now in the middle of this, but it's something worth looking at. So that's kind of the FMLA issue when there's a serious health condition of a spouse or a child. Recall that a child is defined as someone 18, under the age of 18. However, if you do have an adult child who is ill, that illness may still qualify if that child, adult child, is incapacitated, incapable of self-care. And I suppose if someone has a very, serious version of COVID, they may need someone to help them with some of their day-to-day things, help feed them, perhaps help them ambulate, help them use the restroom, all those different things, then that could qualify. If, however, someone has a really mild case, they're really okay, they just need to isolate that, and they're an adult child, that likely is not going to qualify for FMLA. On the other hand, just a younger child, non-adult child, who just might need someone to oversee what they're doing, and they do have the illness, or a parent that needs some help Parents do not necessarily have to be incapacitated, but you're providing some help to them. And even the courts have said in typical Fmla that just moral support, spiritual support, other sitting and holding people's hands and making sure they're not lonely, that they take a pretty broad view of that for parents. So, but you'll need to check and see exactly how bad someone's COVID might be to see if it qualifies for the adult child or the parent. What's another obligation that you might have, and what's another option for employees? And that's the Illinois Sick Leave Act. And this has been around maybe 3 years or so now, and I'm not sure it gets all the attention that it's due. It doesn't provide a lot to employees, but it provides a little, and you need to be aware of that. Importantly, the Illinois Sick Leave Act does not require you to provide paid sick leave to your employees. It does not require you to provide unpaid sick leave to employees. It merely says, if you do have a sick leave policy, and many employers certainly do, maybe it's only 3 days, maybe it's a week, maybe it's a couple weeks, whatever your policy might provide. Or if you have other forms of leave that you allow your employees to use for sick leave purposes. So maybe you've got an all-inclusive paid time off plan that employees can use for vacation, illness, personal, whatever. Maybe they have personal days you allow employees to use for illness. Maybe you have vacation that you allow employees to use for illness, whatever the case may be. If you allow them to use paid time off for illness, then the statute requires that you allow the employees to use them, quote, due to an illness, injury, or medical appointment of the employee's child, spouse, sibling, parent, mother-in-law, father-in-law, grandchild, grandparent, or step-parent. So that's clearly it's a broader definition than of a family member we find in the Fmla. So if your employee has one of these additional employee or family members, the mother-in-law, the father-in-law, who are not covered under Fmla, only biological parents and local parentis parents, grandchildren, grandparents, step-parents, et cetera, aren't typically covered under Fmla. They would be covered under this Illinois Sick Leave Act if you provide that benefit. So there's a little bit broader there, although again, probably the time off is not very much. And I suspect in many cases, if people have already had COVID or family members have had COVID already, again, it's like they've burned through it all, which again, references us back to what does your policy say? When do individuals earn sick leave? As of 1/1, do they get a new bucket full of sick leave or paid time off or vacation that they'll get to use? Or is it something you earn pro rata? You put a little bit in the bucket at a time. However you define that. And if you don't define it, you take a look at those policies. It's important that you define how vacation is earned and available. This might help an employee out a little bit, depending on the amount of sick leave you give to employees. Outside of that, those are some of your legal obligations, some of the employee legal rights. What other options are there for employees who have to take care of a family member due to illness? Well, some things you may have done already, telework. And again, employees, kind of going back a little bit to FFCRA, employees are entitled to emergency paid sick leave, or they're entitled to emergency FMLA if they cannot work or cannot telework. If individuals can telework, then it is not, they're not entitled to leave under FFCRA. But can they telework? Some jobs that might work. We've had a lot of people within our own organization who teleworked or may continue to, at least part-time. But if you run a manufacturing facility, you can't really telework when you got to be running that machine, right? So that might not be a good option. Leaves of absence. Again, look to your employee handbook. If you don't have a general leave of absence policy outside of any statutory obligations, I would certainly recommend that. What does it say? Do you provide some brief leave of absence? Whatever it says, follow it. It's available to your employees. The handbooks we draft, many of the clients we work with, a 30, 60, maybe 90 days would not be unusual. And again, maybe your employees have already burned through that. non-statutory leave of absence already this year. Again, look at your policy. When does that bucket get refilled? Is it annually? Come January 1, maybe they have some entitlement under your policies to additional general leave of absence or whatever the case may be. That's why it's very important that you look at how it's drafted. Those things sometimes become clearer when we actually have to use them in these tough situations. Another potential solution, again, things you might be doing already is shifting when people work. Maybe someone is on the day shift and you've got a night shift, and maybe spouses can trade off something maybe you've tried already earlier, and maybe that person can run a machine for you second shift. Are there openings on your second shift? There's some availability there. You wouldn't have to do that, but if you wanted to, you could certainly try that. Or just shifting telework when hours are done. Yes, it's hard for me to work when the kids are at school or whatever the case may be, or when I'm taking care of my loved one who's ill, but in the evenings, when again, maybe someone else comes home to help take care of them, now I can maybe do some work from home, but from 6 p.m. to 12 midnight. Does that work for you? Sometimes that might work, other times it might not. Those really, and be creative. Things you probably have tried already. If you haven't tried some of these, maybe think about how those might work and play into your organization. But whatever you choose, obviously you need to apply that consistently to all employees. You certainly want to say, well, I like this person, I'll let that person have this leave, but I don't like you, so I won't. Not a good reason. When we are inconsistent in how we apply work rules or give work benefits such as paid time off or leaves of absence, we certainly can always run the risk of discrimination or other sorts of lawsuits. So consistency as best you can. We'll have situations where there are aggravating circumstances, mitigating circumstances. We need to maybe do something a little bit different for him, but maybe it's the 80-20 rule, right? 80% of the time, this is what we end up doing. 20% we might have to revise and take a look at how we're handling things. But as best you can, try and be consistent. So that's if family members are sick. Well, what about the school age children? What if the employee has exhausted all Efmla? Because again, regular FMA is not available. Regular FMA is the serious health condition of a child or the birth of a child. There's nothing in the regular FMLA that has anything to do with the fact that a child is home because school is closed or because a daycare is closed. Potentially, I suppose, the only difference might be upon the birth of a child, within the first year, you can take up to 12 weeks off really for any reason, for child rearing purposes. So if someone has a brand new baby, and regardless of whether they've got daycare or not, they could use those FMLA up to 12 weeks in a year. Again, look at how you define year for child rearing purposes and child bonding purposes, but only during the first year of the child's life in that situation. What are those options? And really, they're really not much different, or perhaps any different than if the child were sick or a family member were sick. Do they have remaining paid time off? Now, there is no Illinois sick leave issue here, but do they have PTO? Probably they burn through that. Can they telework? You've likely looked at that. Does that work? What about unpaid leaves of absence? What about shifting work hours, and that sort of thing? Is that going to work? Those are really, I think, the options that are out there. And I would certainly, if you've got other ideas, let us all in on it in the Q&A. These are things I've talked about with my clients, and when I read probably made the same articles from law firms and others to get some insight into how others are handling it. These are the basic things that are out there. I'm not sure there's a whole lot more to think about. And again, whatever you decide, apply consistently to all employees. I would say there are, however, a couple year-end issues to be aware of as it relates to EFMLA or the children being home. Recall that as we come towards the year end and after 1/1 or at 1/1, EFMLA goes away, recall that the reason for the child being home has to be because school is closed or daycare is closed because of a COVID-related reason. Now we're coming up likely on our whatever you want to call it, Christmas break, holiday break, winter break, the time typically probably next week through after the first of the year when schools will be closed. That is not an EFMLA qualifying event. School is closed because of the holiday. School is closed because that's been on the school calendar. School is not closed in that case due to COVID. So understand that that time off that's for winter break. I know a lot of schools are canceling spring break, but the winter break, Christmas break, holiday break, semester break, whatever you call it, that is not going to be an EFMLA qualifying event. Employees who are taking time off because the kids are home because school is closed for holiday reasons and not because school is closed because of COVID reasons, that doesn't qualify. And so employees, you could pay them if you want, nothing wrong with that. It would not go against their EFMLA use. Of course, that goes away at the end of the year anyway. But importantly, you cannot take the tax credit for that time as well, because obviously at 1231, not only do the leave provisions go, the tax credit provisions that pay for that leave, they go away as well. You know, what else do you need to think about, I think, as we consider employees who have to stay home because their children's school is closed in that tough situation? You know, are you prepared to terminate the employee? Could you? The answer is yes, you could. Should you? That's a decision you have to make. Likewise, are you prepared for employees perhaps just to say, I quit? I'm sorry. I got to stay home with my kids. I've got no other option. You know, how does that impact your organization? Do you lose key employees? Would you be better off extending an unpaid leave of absence? You know, those are all some difficult questions that will vary from organization to organization and perhaps from job to job. Again, shop floor versus someone who might be able to telework, those sorts of things. But keep that in mind as well, that you may put your business in a tough position to losing key employees because either you just need someone in that job. Sorry, it's a key role. Someone has to be there. If you can't be there, I've got to hire someone who can. Or someone saying, I'm going to have to quit. I don't have good answers to that one, but if you do, I'd love to hope you share them. What about issues if the employee has to quarantine? A little bit different scenario there. Not a lot different, but some things are. Excuse me. So has the employee, again, exhausted all emergency paid sick leave? And the same issues we talked about when the employee was taking care of a spouse, child, or parent with a serious health condition. You know, that's, yes, that likely the employee has COVID, that's a serious health condition. Do they have any of their 12 weeks remaining? And again, how do you define it? On 1/1, will that bucket refill, or do you otherwise define the 12-week periods in a different manner? And again, what are the other options? Well, again, Illinois Sick Leave Act, they can certainly take the sick leave for themselves, and any other paid time off you would allow them to take if they haven't burned through it already, vacation, PTO, sick, whatever. And again, importantly, look at your policy. What happens on 1/1? Does that bucket of paid time off, sick or vacation automatically refill? Do I have forfeiture provisions? If they don't use it by the end of the year, might I make an exception and say, okay, all employees can carry that over this year and this year only if they've got a balance? Or do they just use it or lose it and start earning pro rata again 1/1? Those are important issues. Your policy should address those, and then obviously just apply them to the situation. And the standard, telework, if available, continue to do that. Leave of absence, per your policy, shifting work hours, et cetera. The same potential solutions you use in those other situations, I think those obviously are here as well. And again, the lawyer in me wants to say, whatever you do, try and be as consistent as possible for all employees. Maybe one slight difference, potentially, for employees' own illness with COVID. Might this be an issue under the Americans with Disabilities Act? Disability being a physical impairment or mental impairment that substantially limits a major life activity. If someone has a mild case of COVID, probably not an ADA disability. If someone has a really short bout with COVID with no lingering side effects, likely not an ADA issue. But what if someone has a more serious response, someone that needs hospitalization for a period of time? What if someone has some, just what I've read, have some lingering effects of COVID as far as extreme fatigue and some other things? Might that be a disability? And the answer is it very likely could be, because it would be that physical or mental impairment and it's ongoing, or it's more than just very, very short term. In that case, you would have an obligation then to provide a reasonable accommodation. What are some reasonable accommodations? Well, some things you might have tried already. Telework might be a reasonable accommodation. A leave of absence could be a reasonable accommodation, unpaid. In the Seventh Circuit, where we're at, that's the federal appellate court jurisdiction for Indiana, Illinois, and Wisconsin. There was a case a few years ago that said, what's a quote, reasonable accommodation when it comes to a leave of absence? They tightened that up quite a bit. And, they said, yeah, maybe it's only a couple months. Tops would be a reasonable accommodation. Understand that other courts throughout the country, though, have said that no, a reasonable accommodation might be months, 6 months, 9 months might be reasonable, because it doesn't cause you an undue hardship just to leave that person on a leave of absence. So at least in the Seventh Circuit currently, the issue has not been decided by the Supreme Court. That quote reasonable accommodation as applies to a leave of absence is probably in that several weeks to maybe a couple months range. So again, if someone has lingering effects of COVID or a more serious thing that requires hospitalization, that very well could be that disability. And again, obviously the other things we talked about, Fmla, et cetera, employees, that could be their own serious health condition if they have time available. Just checking my clock here, and we are in good shape. Briefly, return to work issues with COVID, and then get to your questions. Again, I get a lot of questions on that, and the CDC has tweaked their recommendations. Importantly, what if an employee does test positive? What should you do? Of course, first thing you do is send that person home if you find out. Then we do some contact tracing. Ask that employee, who have you been in close contact with? And close contact, that definition has changed a little bit by the CDC over the last months. And currently it's been within 6 feet of an infected person for a cumulative total of 15 minutes. Before it was just like 15 or 20 minutes in a row. Now it's cumulatively, so 5 minutes here, 5 minutes there, 2 minutes there, 5 minutes there, over a 24-hour period, starting from 2 days before the illness onset. So you want to track those people down. For asymptomatic employees, again, you want to contact those people who were 2 days prior to a test specimen collection until the time. So basically, when we find out someone's sick or has symptoms, we look back 2 days, and that's when we determine close contact. And then, of course, you can inform that employee that they have been in close contact with someone who is tested positive for the COVID virus. You cannot identify that person. That would be a violation of the ADA. Now, people may know, well, Charlie's or Mary, they're the only ones gone. That's probably them. Maybe people figure it out. But it would violate the ADA if you provide them with the identity of that individual. When can those people return to work? For someone who had symptoms. Well, this again is tweaked a little bit over time. There's two strategies: one symptom-based, and that person can return to work, absent other advice by a public health department, absent other advice by, that's always the caveat, or by someone's physician. They've had no fever for at least 72 hours without the use of fever-reducing medicine, so no Tylenol, no aspirin, that type of thing. That other symptoms have improved, so they no longer have a cough, et cetera. And at least 10 days have passed since the symptom first appeared. Then they can return to work under this strategy. There's also a test-based strategy, which may be a little bit harder to do with increased testing. But this strategy, no fever, symptoms have improved, and instead of waiting 10 days, you have 2 negative tests in a row, at least 24 hours apart. and then that person can return to work. I've been hearing from others that the Department of Health and physicians may not be advising this one because, one, the testing takes so long still in some cases, or two, you might still test positive even after your symptoms are gone. It might otherwise qualify under a symptom-based strategy, but for some reason, you're still testing positive for the virus and you're not infectious. So, but those are those options. What if someone was asymptomatic? When can they return to work? Again, the time-based strategy, similar to the symptom-based strategy, but since they're asymptomatic, but they don't have symptoms, at least 10 days have passed since the first positive test, and they continue to have no symptoms. Then someone could return to work. Or the same test-based strategy, employee can return to work after 2 consecutive negative test results at least 24 hours apart. What about those exposed employees, those who are in close contact either at work or potentially at home or somewhere else? Again, with the caveat, unless it's otherwise directed by the Department of Health or a physician or healthcare provider, what is allowable? And again, the CDC is going to come back and forth and back, and now they're back to the more or less their original advice here. The exposed employee should stay home until 14 days since the last exposure. During that time, maintain social distance and self-monitor for temperature and other symptoms. And after that 14 days, they can return to work. Of course, obviously, if anyone develops symptoms in that 14-day period, then we revert back to some of those other issues regarding an infected employee with symptoms that we just talked about. The CDC did come up with a reduced quarantine option. It does clearly warn that this is not necessarily the best option. There's an increased risk of infection to others using the reduced quarantine option, but currently, at least as a couple of days ago, it was still on their website. And so instead of returning after 14 days, you can return after 10 days after last exposure if no symptoms have been reported during daily monitoring, or kind of a test hybrid option. The exposed employee may return to work on day 7 after the last exposure, and there was 1 negative test result, and that test result has to occur at least 5 days since last exposure, which means you need to get like a 2-day turnaround on a test result, which sometimes can happen with a rapid test. Otherwise, if you're going to through the health department or locally here, it's like, for example, the College of Medicine, it likely is going to take longer than that to get your results back. At the conclusion of an early quarantine, continue to watch for symptoms until that 14-day period has passed. Wear a mask at all times, and socially distant. And obviously, if you develop symptoms, immediately self-isolate and go back to those other provisions we talked about. And again, to emphasize, any option to shorten quarantine risk is less effective than the currently recommended 14-day quarantine. I will provide a copy of this, or Pam actually has it. I'm sure she'll be able to provide you a copy of the presentation for some of these links and information. There is a critical infrastructure employees can come back or continue to work if they've been exposed. The CDC has changed their advice on this. It used to be, they used to think it was more okay, if you will, to allow people in critical infrastructure jobs to return to work even if they have been exposed. Now they're seeing this really as a last resort. There are many different critical infrastructure sectors. Here are some of those. Some of those you think of. But for that employee to return, if he's been exposed, continue to work, must be asymptomatic and really used only if it's necessary to preserve the function of critical infrastructures. And per the CDC, this option should be used as a last resort and only in limited circumstances, such as when cessation of operation of the facility may cause serious harm or danger to public health or safety. So kind of a last resort probably doesn't apply in most situations. If you can avoid it, this probably isn't the best option, but understand that it is out there. Now, and while those critical infrastructure employees are working under this option, they should pre-screen at home. So take their temperature and check for symptoms at home. You should screen them at the workplace, preferably before they step in the building. They should regularly self-monitor at home and during work. They have to wear a mask at all times in the workplace. They need to maintain social distancing, and you should continue to disinfect and clean their workspace. Briefly, before we're in good shape. Now, what does the future bring under the Biden administration? And again, nothing except what I've read or checked on websites and a little research. I don't know if I got any great insight, but as kind of applies to, the COVID issues, you can look at really what President-elect Biden has put out on the web. It's buildbackbetter.com priorities. It's kind of what his plan is going. It has lots of issues, but as relates to COVID, he wants to provide a restart package. Some of the things that might be in the current bill to help small businesses, covering operating costs, including things such as personal protective equipment, the like. Provide state governments with money, extend unemployment, which is in the current bill to get signed. But importantly, as we get down to in brass tacks, how does this might impact COVID issues now and going into the future? One of the President-elect Biden's priorities is, quote, he will sign legislation for universal paid sick leave and 12 weeks of paid family and medical leave. There have been provisions, bills, I should say, that have been introduced in the Congress before, and they typically don't get very far. But this would be a priority of the Biden administration. If that gets into place, perhaps next year or before the pandemic is really under control, hopefully we're out of this by next summer or fall to a great degree. Understand that this universal paid sick leave is coming down the road and may very well be something that happens. Certainly, it's been something that's been kicked about in Illinois for a while. There is a current House bill, and that'll go away with the new General Assembly. Likely will be reintroduced. It's been reintroduced over the last couple of General Assemblies that would require 6 weeks of paid leave for typical FMLA covered employers, and not really because of illness, but for the own employee. But for the illness of a family member or for the birth, foster care placement, or adoption of a child. So those things are kind of, what's coming down the pike at some point. I think no one would be surprised if eventually these paid sick leave provisions don't make it to the president's or the governor's desk, and they would sign those. Oops, I'm through with that. Any questions or comments? And I will give up control of the presentation so someone else has it right now.
Thank you very much, Sam. I really appreciate it. This is really informative. I don't see any questions. I just want to remind everybody you can put your questions in the Q&A box, and then I will share them, and Sam will do his best to address them. But I do have a few questions as they're doing that. You mentioned that the FFCRA addresses fewer than 500 employees and the FMLA is more than 50. If you have less than 50 employees, where do you fall into this? Does either one of those qualify?
Right. So if you have fewer than 50 employees, and again, the test is 50 or more employees for 20 or more work weeks in the current or preceding calendar year. So if you, for example, I had 50 employees for most of this year, you've had to lay some people off, and you start in 2021, even if you only have 49 employees starting 2021, if you've had 50 or more this year, you're covered. So if you, again, have fewer than 50, you are not covered by the FMLA. You are currently covered by the emergency family medical leave and emergency paid sick leave through the end of the year. Once we hit 1/1, assuming there's no extension of emergency sick leave or emergency FMLA, then you smaller employers, you're not covered by FMLA. Those provisions go away. Now you're kind of left on those other issues we talked about, perhaps a little bit of Illinois sick leave issues, and then what you want to do voluntarily as far as unpaid leaves of absence, teleworking, job changes, et cetera. And you that have more than 50, obviously, or 50 or more as of 1/1, you continue to be covered by FMLA. But any EFMLA they used, depending on how you count 12 weeks in a 12-month period, that would continue perhaps to count against their FMLA balance.
Okay. Now you mentioned, sometimes people are exhausting their sick and vacation time and they don't qualify for some of these other benefits. We have a large number of businesses that may be on the line or that are in our community. What if they've exhausted all these options? Is the option for the employer to terminate an employee, is that an option if they're not coming to work and they can't keep the position open and they need to fill it? Is that an option for them?
It is an option. And so I would look at that, carefully just from the HR and the employee relations side of things. But certainly there will be the tough decisions that, I need someone to run this machine. I need someone to fulfill this function, and teleworking is not going to work for some reason, and you can't come to work, or maybe you're, even if you are at home, teleworking might work, but you've got to watch the kids, and so that's not working, whatever the case may be. Yes, at that point, you certainly could terminate, assuming you've exhausted, the employee's exhausted, their EFMLA or emergency paid sick leave, or they've exhausted their regular FMLA leave. Once that's done, there's no more legal requirements, except perhaps we mentioned, ADA issues in the cases where someone might have a more severe COVID reaction. Outside of that, once I've fulfilled those legal obligations, there really aren't any particular job protections. And outside of the suggestions we've had about, again, teleworking, shifting hours, et cetera, those aren't going to work. Then that hard decision might have to be made that I've got to fill it. I'm sorry, I'm going to have to terminate you. Obviously, that person becomes entitled at that point to unemployment compensation. But yes, that might be an ultimate decision some employers are going to have to reach.
Okay. And you mentioned the series of COVID, and it's with confidentiality in the business, in the workplace. We've had some employers that were kind of challenged where, you have HIPAA, you have protection for the individual, the information that they're providing you. At the same time, they've come in close contact with a team on a line or, in their business. And how much information can they share? Because they have a responsibility to those other workers as well, to make sure that they're not bringing that home to their families.
Right. And so, what, again, is advised by the CDC and tempered by what you can say under ADA and other restrictions, you would just have to say that you've been exposed to the COVID virus, you've been in close contact with someone who was tested positive. And then, then those individuals should be sent home. So you can certainly tell them that they were in close contact with someone, they've been exposed to someone who was tested positive. I just can't say, oh, by the way, Sam Castree, it was Sam Castree, or whoever it might be. Now, again, in smaller and even in larger organizations, sometimes we're going to say, well, everyone's here but Sam. I bet it was Sam. And you got to say, can't tell you. People might be able to figure it out, which is different from you telling them who it was. But you certainly would have that obligation to let them know you've been exposed and you've been in close contact based on that definition to someone who's tested positive. That person should then be sent home. And then you can follow the 14-day quarantine or the shortened 10-day quarantine, or some of the other options we've talked about earlier today.
Okay. And, I know you work with a lot with employee handbooks and such, and some businesses do have one or have something, but there's a number of businesses that don't. Do you suggest that they actually put something in writing to their employees, put together some policies, or adjust their current policies to make sure that people are wearing masks, that we're being responsible, social distancing? What changes do you think that they should make more formal?
Right. My clients have handled it a couple different ways. I think certainly having a written policy is a good idea. And whether you integrate that into your employee handbook per se and issue a new handbook with a pandemic policy, which some of our clients have done, or whether you just say, here's our new pandemic policy. We're not necessarily putting it in the handbook, or we're not going to put it in now. And hand out copies to everybody and post it on the bulletin board. Or if you use a some sort of electric bulletin board or whatever, get it out to employees. I think that's a good idea. And importantly, it falls on supervisors to enforce the policy. I think all of us, some of us to our great frustration, have gone to grocery stores or the various retail outlets where employees have a mask that's not covering their nose, or a mask that's not covering their mouth, or no mask at all in rare cases. That's certainly, from an employer standpoint, those employees are exposing other employees, not to mention the customers and clientele. And so importantly, it's important to get that information to employees, and then just as important for management to enforce, supervise those things. And when they see it's not being followed, obviously to enforce the policy, because you don't want other employees getting sick. And for those organizations that have a lot of contact with the general public, obviously you don't want your patrons getting sick either.
Well, thank you, Sam. I don't see any more questions. I wanted to thank you for, again, joining us and sharing your expertise. Again, I would take full advantage of reaching out to Sam if you have further questions that may be more specific to your situation, or refer him to businesses that you work with. I want to also thank everyone for attending today. And again, you can find more information on forwardboone.org. And we'll send out this presentation to our attendees as well. Again, thank you. Thank you for everyone for joining us again. Thank you, Sam. Appreciate it.
You're welcome. Pam, take care, everyone. Have a good day.
And happy holidays to all, and stay healthy.